The Canadian Charter of Rights and Freedoms protects a lot of rights, from democracy to expression, liberty to security of person. But what if these rights are violated? Imagine the police detain you for no good reason, or they search you and don't find anything. Or what if the government discriminates against you because of your race or gender? Do they have to pay up for these violations? And if so, how much? To answer this, I'll have to tell you about an imaginary pie, obsolete water fountains, and 27 years in prison. First, it's important to know that the Charter has 3 different remedy clauses. Section 52 is used to strike down unconstitutional laws. For example, the criminal code provisions prohibiting assistance in dying were declared invalid because they violated the rights to life, liberty, and security of person. Section 24(2) is used to exclude evidence that's been obtained in violation of the Charter. For example, if the police detained you and searched you without a warrant or other good reason and found some illegal drugs, those drugs might not be admissible against you if they lay criminal charges. Section 24(1) is the clause that we're focused on today. It's a catch-all provision that gives the court such remedy as the court considers appropriate and just in the circumstances. This can include a wide variety of remedies, such as a declaration that your rights have been violated, an injunction prohibiting the government from doing some conduct in the future, a mandatory order requiring the government to do something, and, of course, monetary damages. But monetary damages are far from common. In fact, even though the Charter was enacted in 1982, the first Charter damages were not awarded until 2010. And it was all because of pie. One summer afternoon, Mr. Alan Cameron Ward was walking down the streets of Vancouver to attend the grand opening of the Millennium Gate to Chinatown. Unknown to Mr. Ward, the police had received information that someone was planning on throwing a pie at Prime Minister Jean Chrétien, who was also at the ceremony. Mr. Ward partly matched the description of the suspect and appeared to be running, so the police approached him and told him to stop. Mr. Ward refused, and the police chased him down the street and handcuffed him. Mr. Ward protested loudly, and even TV crews came to watch the commotion. The officers arrested him for breach of peace and took him to the police lockup. There, they told him to remove his clothes for a strip search. He stripped down but refused to take off his underwear. The police gave in and conducted the search without touching him. He was then locked up in a small cell and released without charges 4.5 hours later. No pie was ever found. Mr. Ward, who happened to be a lawyer, then sued, saying that it was an unreasonable search in violation of Section 8 and arbitrary detention in violation of Section 9 of the Charter. The case went all the way to the Supreme Court, and in that decision, the court said monetary damages could be given for Charter violations for 3 different purposes. First, compensation. This is to remedy any loss caused to that specific person by the Charter breach. Second, vindication. This is to address the harm caused to the state and society at large rather than to the individual themselves. And third is deterrence. The goal of this is to influence the government's behavior to stop them from violating the Charter in the future. The court said that the amount or quantum of these damages should be appropriate and just to meet these 3 goals, and that damages shouldn't be handed out if there were other non-monetary measures that could meet these goals. The court also said that damages shouldn't be handed out if it would interfere with good governance. By this they meant that people shouldn't be awarded monetary damages when an unconstitutional law was struck down under Section 52, unless the government acted in some way that was clearly wrong, in bad faith, or an abuse of power. This is because the rule of law would be undermined if governments were deterred from enforcing a law simply because of the possibility that it might be struck down in the future. The court found that Mr. Ward's arrest was reasonable, but that he was held for longer than necessary, and for this he was awarded $5,000 for the tort of wrongful imprisonment. This was under the common law and not under Charter damages. As for Charter damages, Mr. Ward was given $5,000 for the strip search because it was an unreasonable search under Section 8. But not every Charter violation is worth $5,000. In fact, it turns out that the spectrum is quite large. Let's see how this is played out in practice with 3 cases, starting at the bottom of the spectrum and working our way up. First, near the low end of the spectrum, we have Michel Thibodeau. Mr. Thibodeau worked on Parliament Hill fixing computers, and while working in the East Bloc, he noticed a serious issue with some of the water fountains. Their buttons contained only the word push, and did not contain the equivalent in French. Mr. Thibodeau filed a complaint with the Commissioner for Official Languages, who concluded that this was a violation of the Official Languages Act. However, in the meantime, the Senate installed a bilingual sign above the water fountain, helpfully explaining, to activate the water fountain, please push the button. They couldn't replace the actual button itself because the water fountain model was obsolete. Shortly after the Commissioner's report, the Senate also issued a letter of apology to Mr. Thibodeau. Mr. Thibodeau took the Senate to court, and the federal court found that Mr. Thibodeau's Section 16 language equality rights were violated because the Senate could have used some plastic self-adhesive labels to attach the word pousse directly to the metal button, but for some reason failed to do so. While there was no need to compensate Mr. Thibodeau for any financial loss, the court awarded him $1,500 to compensate him for his time and effort in correcting the wrong, and for the purposes of vindication and deterrence. Things start to get quite a bit more serious with our next case, Al-Marti and the Toronto Police Services Board. One January evening, Constables Pack and Poole were driving their police cruiser down the streets of Toronto, and they spotted Mr. Al-Marti on the street. Constable Pack observed that Mr. Al-Marti was black, and had a hunch that he might be violating bail conditions. Mr. Al-Marti was not on bail. Constable Poole noticed that Mr. Al-Marti had his hands in his pockets and immediately was concerned that he might be hiding a weapon. It didn't seem to cross her mind that it was a cold winter evening and Mr. Al-Marti might not be wearing gloves. The police officers did a U-turn and turned up alongside Mr. Al-Marti to question him. He responded with some hostility, so the officers got out of his car and asked him to take his hands out of his pockets. He refused, so Constable Pack punched him twice in the face and threw him to the ground. They handcuffed his hands behind his back and left him lying handcuffed on the ice for 20 to 25 minutes while they searched his belongings. Mr. Al-Marti sued the police officers and the service, and the court ordered $5,000 in damages for battery and $25,000 in punitive damages against Constable Pack for the 2 punches to the face and the other violent conduct. As for charter damages, the court awarded $50,000 for many breaches, including Section 8, unreasonable search and seizure, Section 9, arbitrary detention, Section 10A, not being informed of the reasons for his arrest, Section 10B, being denied the right to counsel, and Section 15 for racial profiling. The court focused on the racism and violence as key reasons why the damages were so much higher than Ward's $5,000. Finally, we come to the big one, Henry and British Columbia. From 1980 to 1982, a series of sexual assaults were carried out in Vancouver. Police identified Ivan Henry as one of multiple suspects. He was forced into an identification lineup, and while in the lineup, an officer held him in a headlock in view of some of the complainants. Some of the victims identified him as the perpetrator, but others did not. He was later identified by a victim in a photo lineup where all the other men in the pictures looked significantly different from him, and he was pictured in front of a jail cell while the others had neutral backgrounds. Mr. Henry was charged and requested disclosure of all the victim statements as well as medical and forensic reports, but the Crown did not disclose any of this material until the trial had already started. Even then, the Crown never disclosed 30 of the victim statements nor the sperm from the crime scenes. The Crown also didn't disclose that another suspect, Donald McRae, had been arrested twice in the area of the attacks. In the end, Mr. Henry was convicted of 10 counts of sexual assault. He was declared a dangerous offender and given an indefinite sentence. This meant that they could keep him in prison forever. After spending 27 years in prison, Mr. Henry was released and acquitted of all charges. He was awarded around $8 million in charter damages, around $500,000 in compensatory damages for his lost wages, and around $7.5 million for vindication and deterrence. So there you have it. We've seen charter damages as low as $1,500 for mislabeled water fountains, and as high as $8 million for 27 years of wrongful imprisonment. What do you think? Are these the appropriate amounts? Do you think they adequately address the 3 goals of compensating the harmed person, vindicating the right in broader society, and deterring the government from violating these rights again? Let me know in the comments.